Wood. I'm a professor. Oh, thank you very much. Uh, I'm going to start again because now we're recording. My name's Stephen Wood. I'm a professor in the law school and the director of the Center for Law and the Environment. I'd like to welcome you to the second of our Center for Law and Environment speaker series talks of this term. The first one was on September 10th, and it was about rights of nature in Colombia. Today's is about sustainable development, international law, and African cosmologies. And I will introduce our speaker in a moment, but before I do that, I want to take a moment to acknowledge that we, at least who are in person, are gathered on the traditional, ancestral, and unceded territories of the Musqueam Nation, the Squamish and Tsleil-Waututh nations. I think it's useful to recognize that the indigenous legal cosmologies of those nations and other Coast Salish people there we are, have been in place on these lands for millennia and have informed millennia of stewardship and sustainable guardianship of the lands and waters by the peoples of this area, which I think is significant because today we're going to hear about the influence that indigenous African legal cosmologies could have and are having on the development of international law in relation to environment and sustainable development. Our speaker is Godwin Dzah, who is to my right. You can't see him at the moment on the screen, but he'll be here just shortly. Godwin is an assistant professor in the Faculty of Law at the University of Alberta in Edmonton. He is a recent graduate of the PhD program here at Allard, and we are very proud and honored to have an association with him and that he's happy enough to come back to Allard to promote his new book that's just out from the Cambridge University Press, one of the world's leading academic presses. And you can see on the screen that what this beautiful book looks like. He's also brought a copy with him. I'm able to hold it in my hands. Sustainable Development, International Law, and a Turn to African Legal Cosmologies. He's mainly going to speak about this book that has just come out. Godwin's research interests include international, environmental, and comparative law. He was a postdoc at Osgoode Hall Law School over in Toronto. He's been a visiting fellow at the Schulich School of Law at Dalhousie in Halifax, and a United Nations Fellow at the Office of Legal Affairs, the UN Secretariat in New York. He has a BA and an LLB from the University of Ghana, an LLM from Harvard Law School, a PhD, as I said, from right here at Allard, UBC. He's received numerous awards, including being a two-time recipient of the John Humphrey Fellowship awarded by the CCIL, the Canadian Council on International Law. His doctoral research was awarded the faculty-wide thesis prize, or dissertation prize, pardon me. And in addition, and I'm sure this is only scratching the surface of his many activities and accomplishments, he has acted as a consultant to government and international agencies on law, environment, and development. We are recording today's talk on the Zoom, and there are a number of people with us via Zoom. What I would say is that we will have time for discussion, question and answer after Godwin is finished speaking. And Isabella, the coordinator of the Center for Law and the Environment, who's here in the room, will take your questions through the chat, I guess. Is that right? There isn't a Q&A function, is there? So if you have questions, pop them in the chat. And when it comes time for the Q&A, we'll try and take things from both the room and the Zoom. Thanks very much. Please join me in welcoming Godwin Dzah.
Thank you, Stephen, and thank you everyone for coming here today. I'm really delighted to see that on a Friday, the room is almost full. So that's wonderful. And thank you to those on Zoom. There are many of you who wish to be here physically, but you're still with me nonetheless. So I appreciate. Now, let me begin by saying that I came to this work with many lenses, but importantly, I came away with it also with so many other lenses. And I've been enriched by my time here in Vancouver and also at UBC, particularly the interesting and respectful work that goes on here at the intersection of international law and indigenous law. And so I spent my evening last night at the Museum of Anthropology. I'm sure law students, you should spend a little more time outside the law school. The Museum of Anthropology might provide some more insights as to how to understand your engagements with law. And I spent that time, reflecting on some really important indigenous practices, which are performative in themselves, but they are also legal principles actually in practice. So that's just to put out there. Now, I want to begin by thanking the Center for Law and Environment at the law school here at UBC for inviting me to talk about my book here. And I'll gladly pass it around as I'm talking so people can have a feel of it. I'll take it back. Right. And to thank Professor Stepan Wood for bringing me back. For those of you who don't know, I was Stepan's first hire when he arrived here at the law school in 2017. So probably I'll be a dean of your RAs when we are more than 10. Right. And to thank Isabel Chopper as well for her excellent work in coordinating my attendance and getting me here. I would like to express my sincerest appreciation to all of you in the room today and to the many who are joining us on Zoom. But more importantly, I would like to begin by thanking once more the people and ancestors, not just of this land, but of all lands that still hold dear their traditional and indigenous values, and to say that we are here because they have allowed us and permitted our presence here. Now, I'm sure you're not here for that, so I'll go to the talk. I'm quite sure that most of you, or let me say everyone, may not have read the book yet. So my job is to do a good job of bringing you closer to making a decision to pick this book off the library shelf or to quickly go on Amazon or Cambridge website and get a copy for yourself. So I'll set about doing that by talking about three key things. The first is that I'll talk about the book's main arguments. And the second, I would focus on the methodology because I think that would be very interesting for some of the students who are here, especially for graduate students, and also for people who are thinking about these kinds of work generally. And then the third, I'll look at the contribution that I attempted to make in this work, my very modest contribution. Now, to the book's main arguments. Now, this question that this book attempts to answer centers on what international environmental law might look like from the perspective of the Global South. For those of you here, let me just say that that question was asked by no other person than Professor Karen Mickelson, who is seated in this room. So I came away with my own project building on work that had already been done, but taking a different twist to what Karen Mickelson had done in her very foundational work that directed me in this regard. However, I know that that question, and as I've said in my book on page 7, is inherently overly broad. So it was important for me to narrow down to address a relatively manageable question within the broader context of international law. So it is in this sense that this book looks at the intersection of Africa, international law, sustainable development, and in non-Western perspectives as a platform for addressing how sustainable development can move beyond its Eurocentric hold. So the main arguments I make in this book is divided along the three broad parts of this book. And if you look at the table of contents, you'll see that the book is split into three separate parts. So the first part, or the first argument I make addresses the concepts of sustainable development. And in this regard, since the concept made its way into international law, at least as the classical textbooks would tell you, if you're reading Alexander Kiss, or you're reading Diana Shelton, or you're reading Philip Sands, they all will try to periodize it around 1972. I disagree with those periodizations. But more importantly, the concept had been able to flourish and become a unifying force in its attempt to mediate development and environment, and then along with that, tackling social considerations, however we define social considerations in that process. And so you see legal scholars like Jorge Vinuales, who argue that sustainable development's ability to sustain itself over the years is essentially a diplomatic trick that generated a great deal of compromise and consensus, and this is it, without truly addressing how to deal with the hard questions that must be addressed in balancing the three pillars of the concept here: environment, development, and society. However, to understand how sustainable development survives as a diplomatic trick, I argue that we need to examine the tripartite constitution of sustainable development through law, through politics, and through history. And so very much at the outset of my work, I engage with all these three ideas and how they come together and how they come apart in the way they treat sustainable development. I argue that this is largely what the logic of sustainable development is, that its ability to unite these three forces without essentially answering the main question that it needs to answer, that is environmental protection. In this regard, the first part of the book focuses largely on a genealogical analysis, where I try to identify how sustainable development as an idea has evolved over time beyond its 1972 periodization, going far back into the European encounter, especially with non-European peoples. And in what I describe as a conceptual progression of sustainable development as an idea, human relations within the non-human world starts with human conceptualization of nature, which involved an artificial separation between the human and non-human. I wouldn't be able to spend a lot of time to go into that, but just to flag that. This separation became more prominent with the intermingling of religion and international law. And for the international law buffs here, you recall that one of the most potent forces of disseminating international law was the church, because the Catholic Church especially had worked itself into the European establishment in a way that allowed it to further the interest of the imperial powers and also further its own evangelism. So it was a self-sustaining process. Now, this separation became prominent then with the intermingling of Christianity and Eurocentric visions of property and dominance. Those who read John Locke and others, you encounter this a lot. But all of these were aided by international law and in the larger project of European imperialism. So effectively, it was at this first stage that we begin to commodify nature and justify all kinds of uses. As society distanced itself from nature, humans constructed the environment as a placeholder, once more, for an idea that really did not have a definitive habitation. In this sense, the environment was an invention at both ends of a broad spectrum. And I talk about a lot of this around page 67 onwards of my work. On one hand, and then in the second sense, it's a loose characterization that justifies the continuous commodification and new uses of nature. So one way it does is that it provides environmental cover. Another way is that it allows us to keep exploiting nature. Now, these early signs of engaging with the environment soon ruptured as international law had to respond to unique concerns of post-colonial states. There's a lot of history in between there, but this becomes more prominent when we get to the point of decolonization. And as I argue in the book, following decolonization, the idea of development, which became the mainstay of international development institutions like the World Bank and the others, reinvented this idea that began with nature through environment, this time through the ongoing geopolitical transformations that the new states, the new post-colonial states found themselves in. So development regrettably carried with it the neoliberal and the new imperial imprint, which traces back to Eurocentric ideas that turn nature into the environment. It would seem then that the allure of development was so strong and became integral to the mission of international financial institutions like the World Bank, the IMF. And so we see here that it was almost impossible to even imagine anything beyond development in the way they contextualize it. In fact, when we talk about development, even now, people think in terms of a building, a road, a school. If you talk about protecting the environment, again, the question is, what is in it for us? So we have to put a money value to the environment. Now, this brand of development, which is very Eurocentric, was just an extension of European imperialism now restyling itself in the course of decolonization. So by the time we arrive at the fourth stage of this period, and this is where I arrived at in the 1972 period, which unfortunately is the starting point of the classical text, because the concept itself had become elusive, if you like, illusory. So part 2 of the book, once we get to the point where sustainable development becomes the mainstay of our engagement with environmental protection, it had succeeded in assuming universal significance in international law. Between 1972 and 1992, barely a 20-year period, the concept had undergone rapid assimilation and dissemination, and it was quickly linked to any cause that deserved global attention. In fact, when we talk about peace, we say sustainable peace. What does that really mean? Just food for thought. So today, it is quickly linked to any cause that deserves global attention. And in this regard, sustainable development, as presently constituted, remains that very strong Eurocentric hegemony that continues to disguise itself as if it was universally accepted, and then in that process avoids any level of deep scrutiny. Regrettably, this false universalism subordinates non-Western ideas and knowledges and their systems of law by forcibly co-opting the approval of non-Western states. I wish I had the time to go into all the historical arguments that were happening in the pre-1972 period leading to the conclusion of the Stockholm Declaration, the birthplace of the so-called idea of sustainable development. I could take that in the question and answer session. So that takes me to sustainable development in Africa. Here, I examine the trajectory of the concept beyond its false universalism to its history, evolution, internalization, and operationalization in Africa. I argue that whereas Africa served in many respects as a laboratory for early developments in terms of international environmental law, being the first place where we had the 1900 so-called Convention on Flora and Fauna and marked later in 1933, all of these do not really help because ultimately African approaches, being African indigenous approaches, were never integral to that process. So I move to part 3, which deals largely with the African condition. Now, we've had the African Commission and the African courts at the forefront of addressing environmental issues in Africa. Yet, as I argue in my book, neither these two tribunals or the many regional and national courts across Africa actively mainstream indigenous African legal perspectives into the interpretation and enforcement of sustainable development. So even though they pay lip service to it in constitutions, there's no active commitment to doing so, basically due to many things, but particularly due to the way we train legal scholars, either in the civil or common law tradition. So there is no real deep sense of engagement with these ideas. Now, I argue that African cosmologies like Ubuntu or Ukama, which are principles that may restrict themselves to particular places in Africa, yet have general application across Africa because they have similar manifestations across Africa, provide us with different ways of engaging. For example, Ubuntu, which signifies I am because you are, is a concept that is not only relatable to human beings in Africa, but also oneness with the non-human in Africa. These are missing in the way we engage with the way we think about sustainable development in the African perspective. So my point is that these concepts can help revive and renew sustainable development with context-specific answers to the kinds of problems that we are facing. It is in this sense that I call them eco-legality or ecological law, as some would call them, but essentially looking at the communitarian values and ethos that they have within them and how a return to those are not necessarily borrowing anything new, but only re-excavating what has already been with us all this while. Because these values is stressed on the fact that the human and non-human are conceptually inseparable. Now you can find most of that in chapters 5 and 6 of the work. To address this issue further, I argue that African indigenous law, that is customary law, can serve as an alternative pathway for reimagining sustainable development. I argue that environmental ethics can establish a new foundation for thinking about ecological interdependence, which draws on the idea of communitarian values and ethos that are already present in African indigenous cosmologies. Now, this means that we were denouncing human dominance over nature, allowing ourselves to go back in time to correct the original sin of the conceptual separation between humans and nature. And with that, we mark the beginning of the road to addressing these many years of eroding the indigenous perspectives that have already guided our traditional societies and ensured balance for millennia until the colonial encounter. I argue then that we cannot look at sustainable development and look at customary law or African indigenous law as peripheral to international law anymore. If you think back to the UN Declaration on the Rights of Indigenous People now taking center stage, not only in the international system, but also domestically. We know, for example, the BC province here has been one of the earliest to incorporate that in its law. The federal government followed that in 2021 with its own law. There's a significant intersection across the domestic and the international, to the point that those ideas are no more peripheral ideas, but they are becoming more centralized. Now, that's on the book. Now, let me do a bit of methodology. Now, as I stated at the outset of the book, you might find this around page 11, I adopt a history-facing approach, and you can tell from my presentation so far that I rely heavily on history to explain how legal ideas flow in and around. Even more, I adopt a third world approaches to international law framework. I wish I could go into that, but simply, Twill critiques international law and the kinds of power relations it creates through what is largely a false hierarchy of not just people, but also ideas. As one of its leading proponents, Anthony Angie, notes, and I was quite lucky to have Anthony write the foreword to the book, he invites us to reflect on the fact that international law has undesirable features, and those undesirable features, we constantly have to engage with them and remove them from international law, making it a better law. In deploying Twill for my work, I argue that history plays a huge role, and so I say any successful deconstruction of the concept can only come from an understanding of how sustainable development itself is a product of a master history of European ideas, and how that idea itself is a constant process in the history-making project of international law. So it's history, but it's also making international law, and in return, it also creates history as it moves forward. So it's a very cyclical way of thinking about how history influences law. Now, I conclude on this by arguing that history then is not just simply a concept, but in this particular sense, it's an amalgamation of legal ideas as it produces a false hierarchy of laws by excluding African peoples and African ideas. Finally, on the modest contribution that I make in this book provides, at least to the best of my knowledge and the knowledge of the editors, the first extensive analysis on African legal cosmologies as a platform for rethinking current approaches to sustainable development in international law. I believe that this book will, in this respect, be a major reference for scholars and practitioners for years to come, as it addresses the question of sustainable development as one concept, allowing for legal scholars after me or alongside me to think about many other concepts in international law which continue to replicate these kinds of questions. And so I take this trouble to extend my own analysis by looking at the concept of aqua nullius in a recent work that is forthcoming in the Canadian Yearbook on International Law, where I look at aqua nullius and how it operates in Canadian law to peripheralize indigenous cosmologies in terms of how they relate to indigenous people and their relationship with water. Now, the second respect, this book proposes embracing African eco-legal principles as the infrastructure for rethinking our human nature relations. And in this respect, the book succeeds in shining light on these principles as capable of reorienting the way we think about the place of sustainable development. And finally, I try as much as possible in this book to highlight some disparities, some deficiencies, and importantly, the politics of exclusion that operates at the heart of orthodox legal scholarship. In fact, the very fact that this book appears in the Cambridge Studies of International Law and Comparative Law in itself runs against the tradition. This was a wild shot, and I'm happy that they took the bullet. In thanking you all and inviting you to read the book, I'd like to say many thanks to my supervisor, Natasha Folder, who's here, for her guidance. And I want to thank many people, and I've tried to do that in the acknowledgements in the book, including Stephen, including Karen, including Pittman Porter, including Gordon Christie, and the list is endless, Margot Young, all of these people who supported me in my time here. And I hope that I've been able to give back a little bit this afternoon. Thank you.
I'm going to ask you to stay up here, Godwin, because we're going to move to question and answer now. For people in the room, this room is all wired up. So if you have a question, when we acknowledge you, what you're going to want to do is press the button on the microphone in front of you to turn on the mic. And then the people on Zoom will also be able to hear. And then, as I said, for people on Zoom, if you have any question for Godwin, please just pop it into the chat, and we'll see how to do it. Either we'll get Isabella to read it out, or we might figure out a way to allow you to pose it yourself on Zoom with your camera and your mic. Does anyone have any questions for Godwin? I'm sure there are. Okay, so I see a question there. Do you also have, do you want to get in line? Is that right? You'll be, okay, so now, just as a reminder, there should be a microphone in front of you. When you begin, can you introduce yourself briefly?
Hi, my name is Trevor. I'm a 1L student here at Allard. My question is concerning sustainable development. I'm wondering, in your view, what is sustainable, or like what is being developed when we engage in sustainable development, and how do we go about, developing that thing? Like specifically in reference to the cosmologies that you mentioned in your talk.
And by the way, when you're done with the question, if you press the button again, yeah, and it'll turn it off, and then I think it'll come back to us. Yeah.
Right. Thank you for the question. This will require a longer answer, but I'll try to make it very short. So as I said in the conceptual progression, the very idea of using resources or nature, let me put it in the initial sense, is one that is not entirely distinct at all. Everybody uses nature. But the idea of extracting value from nature, commodifying nature in the sense that we know it today, is what has transformed nature from that human interrelation with the non-human to a place where nature has become a commodity, effectively moving us into what I call in my progression, the path of development. So essentially, when we talk about development, It's not about engaging in a respectful use of nature. It's about turning nature into a value-driven idea that we can extract something out of. And this was something that became very prominent in the period of European imperialism up until this point.
Go ahead.
Hi, I'm Felicia. I'm with Rio. Thank you for your talk. Very interesting. I have a question specifically about, I guess, resource extraction during and armed conflict, especially in Africa, and maybe we can even go a bit more specific in Congo, and how basically natural resources in Africa get exploited and fund, these horrible atrocities that take place. So I guess I'd like to hear what you have to say in terms of how we can address that issue, that nature has become a commodity, but it's also, funding these atrocities.
Thank you very much. I think that the answer is really with us, but we're not making much progress with it. There's something called the Malabo Protocol in African jurisprudence, which essentially tries to criminalize the use of or extraction of natural resources in an armed conflict situation. This is largely a significant leap in terms of all the discussion that we've been seeing in international law. I know that there's a lot of talk about ecocide and all of that, and the attempts to include that as a complement to the list of crimes under the ICC statute. But if anybody had turned a little bit to look at the Malabo Protocol in Africa, and the fact that that already provides an avenue for addressing that problem, we would have made much progress. The reason the Malabo Protocol hasn't gathered enough signature in Africa remains the fact that countries like the US, countries like Canada, and parts of Europe continue to benefit from conflict-driven minerals. So there the problem lies.
Before you go, Megan, I just wanted to jump on, taking my chair's prerogative. I just wanted to jump on the previous two questions because it actually did relate to a question I was having. I'm sure I would know the answer if I had already read the book, but I haven't. I'm really looking forward to the chance to read it. For you, is your project of the turn to African legal cosmologies in international environmental law, is that a critique or is it a reconstructive project? Do you actually think that the international law of sustainable development can be transformed in the way that you're suggesting, and how would that happen?
I would say you get your answer in the conclusion. That's the short one, but thanks. So in writing in the Twill tradition, my work is both critique and also an attempt at offering reconstructive ideas on how to address this problem. As I set out at the outset of the book, international law has its own challenges, yet international law also allows some reform to happen within it. And so it is in the context of reform that I argue that we can return to these kinds of ideas and use them in very active ways. I gave a couple of examples in the conclusion, which looks at what's happening globally from New Zealand, from South Africa. You would see also in places like Canada, where indigenous law is beginning to take center stage. In fact, the New Zealand Supreme Court makes a very important statement on the idea of repugnancy, which is very known to those who study in the common law jurisdiction. The doctrine of repugnancy is the test against which indigenous law is measured, and if it doesn't meet the so-called Eurocentric standard, it's thrown out. Now, New Zealand Supreme Court just said in 2022 that that test has no place in New Zealand law anymore. That's a very forthright statement. So there is potential to connect these pieces to rewrite a certain new history of international law. So I'll say, for a start, maybe you can skip to the conclusion, and then you can go back to the beginning.
Oh, okay, good. I think Megan is next. And was there one online as well? I thought I saw something in the chat. And I also see this gentleman and Sop. So why don't we do it in that order? Megan, and then the chat, and then you'll introduce yourself, and then Sop question.
Hi, my name's Megan Robinson. I'm a PhD candidate in interdisciplinary studies here at UBC. I'm interested in how, when you look at international law and the history of colonization that exists in the common law legal, do you worry or have concern about sacred cosmologies of Africa being colonized by the law, by the common law?
Right. Thanks, Megan. That's perhaps one of the bits and pieces that I've carried on into other new projects by looking at one particular instance where the sacred natural sites in Africa seem to have been colonized, even recolonized by ourselves using international law. Now, the problem with the post-colonial state is that because the received law, colonial law, continues to be integral to the structure of law itself, there must be a certain sense of awareness that that in itself is a problem, and then a willingness to unpack that problem. We don't see that happening quite often, where African countries themselves, especially the judiciary, tend to make decisions and rulings that largely do not reflect any consistency with cultural norms. And so sometimes when it comes to the implementation of those kinds of decisions, they don't work. We've seen that happen also in the international system, where the African court has failed, in my opinion, in some of the things I've discussed in my book, to take advantage of the situation to make more, front-ended pronouncements on the place of received law on indigenous customary norms. So that in itself is a problem that we African states have continued even long after decolonization.
Try that one, yeah. Oh, yeah, that probably makes sense if you come up to here, so that the mic in the microphone can hear you.
All right. This question is from Ya, and they said Godwin's work is an important step towards incorporating key customs and indigenous knowledge systems into national and international law to make them inclusive and drive sustainable development. Ya would like to know from you as to how you intend to leverage on the knowledge in the book in support of documenting and incorporating indigenous knowledge systems in Ghana and Africa at large.
Thank you, Isabella, and thank you, Yao, for the question. So I'm still struggling with the question of documentation. I've had this question thrown at me in several other places. Documentation is good. The challenge with documentation is that we've seen how much written record, the concept of written record has been used to discipline. And so the societies that evolve can rely on written records, but we must also find a way that allows a cultural evolution that is not stilled in time by the written record. There's a value and place for writing, but we know by scholarship and practice that written record can also be used to discipline. It can be used to include, it can be used to exclude. And so it's something that is important, but something that has to be managed in a way that does not become a problem to the cultural evolution that indigenous ideas are in themselves.
Okay, my name is Jonathan Abagre, and I'm actually a former student of UBC here, long time ago, and Godwin is a very good friend of mine as well. My question has to do with the implementation of international law. So, I mean, between developed countries and that of developing countries. So we have specific cases where, let's say, a Canadian company that operates somewhere, let's say in Ghana, and because Ghana has its sovereign laws, they have strict environmental policies that are in place. You being in a the Canadian system here realizes that whatever is going there is not in reconciliation with standard of practices within Canada. And now, if you want to go back to Ghana or you want to actually sue them from here, it looks like because it's a sovereign country, you do not have that room to be able to operate from Canada in order to, sue them there. And my question has to do with, have your book actually tried to look into maybe how we can actually reconcile this so that at least, even if I'm a Ghanaian, I'm a Canadian here, and there are some unsustainable practices going down there, I can sit here, mobilize people, and be able to sue them there, and at least take the case somewhere that is a neutral ground to be able to at least, get hearing or a fair hearing.
Thank you, Jonathan. I think that this question really falls within the realm of home state, host state obligations, and I think that the Canadian Supreme Court has given us some hope, faintly though, in terms of what we can do when it comes to questions of customary international law. In its more recent Nelson and Araya decision, where it is possible at the preliminary stage that those kinds of actions may be brought into Canadian jurisdiction. But that matter was not a substantive suit. It was basically a preliminary stage question. So while it's still light, it's not fire yet, if I may say.
After your question, we'll have one more, and I think we'll allow, if it can be quick, we'll take two more, and then we'll allow Godwin to wrap up.
Hi, Godwin.
Hang on just a second. Jonathan, you need to press the button on yours. Perfect. And now Sop can press his.
Oh, okay. Yeah, because it was blinking. Right. My name is Sop. I am a PhD student here. My question is not very difficult, or I just want to know how do you handle voice? From what place do you speak? Do you talk like an African person talking to the world, or because I see when you now move to saying you want to talk about in part 3 of your book, African cosmology, do you talk to Africans as an African, or how did you handle that? How did you handle that positionality? Did you say, I want to talk to everyone about Africa, more like introducing the world to say new concepts, or how did you do that?
So like Stephen, I'll send you to page 7 of the book, and I'll just read just to answer you. On that account, the epistemological reference for this critical inquiry is Africa. To the answer, my motivation is evident that as an African, as a lawyer, and as a legal scholar, it is important that this inquiry begins from and returns home. So I speak as all these things, and because I could have many more voices. I don't speak just as a lawyer, but I speak as a legal scholar, and I also speak as someone who is an African. So I hope that helps.
Just a moment, because I think we had then Professor Cheng and then here. If we can I make one suggestion? If we take all three at once, and then Godwin can choose which ones he will add. And please, because we do have to wrap up in 2 or 3 minutes to allow the next class to turn over, if you could be as concise as possible for Godwin, that'll also help Godwin because he has to take 3 in a row. But do still introduce yourself.
Yeah, thank you very much. This is Jie Cheng from the law faculty. I have a question of the inclusive institutions and the historical legacy of the colonial era, because inclusive institutions has become very popular. But the more I read about Africa, I realize that with all the burdens of debt and the colonial institutions, it's hard for African countries to prosper, especially because I'm from China. I know that when China was founded in 1949, it abolished all the so-called unfair treaties, and it abolished all debt. So when I read again Asimov's book, I have some doubts of how Botswana is able to prosper because it doesn't have a lot of debt and the resources only discovered after 1970. So I'd like to have your insights and reflections on that. Thank you.
Okay, thank you. And turn your microphone off and quickly over here.
Hi, my name is Seamus Kurtels. I'm a visiting scholar here at Ellert. Thank you for the wonderful talk. Nice to meet you. So you talked about narrowing down the scope of your book, and I understand that you recognize the hazards of overgeneralization in applicability of the concept of sustainable development by limiting the scope of your book to Africa. But given the diversity and complexity of the worldviews, the cultural understandings of various African communities, do you think your research question is narrow enough to be covered in a single book during a PhD program? So that's my first question, but I think I don't have time for a second question.
Yeah.
Okay.
Thank you very much.
Thank you for the question.
Okay, and one last question.
Hi, my name is Stella, and I know that your focus is on international law, but I'm wondering that this concept of yours of the return to the African legal cosmology, do you see this benefiting the human rights section of the law, having experienced both the African and the Western world theories or lived in here? Do you see that if we returned, if we as a world embraced the legal African cosmologies, if this will help both the Africans to better accept or understand the concept of human rights, other than how it's being forced onto us on a Western world concept and understanding?
Right. Thank you. I'll do one sentence each. So the last question was just really, the question is opening up international law so that others can be included. The second question of essentialization or generalization, to say first that people would always say European, but nobody asks Europeans what really is the European distinction. But when we say African, then they remind us of how different our communities are. So, yeah. And then the third, to Professor Chen's question. So I may say something that's quite provocative to end with, but permit me to say nonetheless. And I talk about it in my book, and I talk about China. So we used to have a problem with North-South, but now we have China in Africa, sometimes North, sometimes South, sometimes South-South, sometimes South imperialism, sometimes South-South imperialism. And I work on natural resources in Africa. So China's relationship is now also becoming synonymous to the challenges that we used to have with the US and the UK in terms of the challenges with development. So just maybe China is not exactly the South it says it is to us in the way the North is to us in the South. Thank you.
So I appreciate everybody's attention. I wish we had more time. The lunch hour on Fridays is shorter than other days. And so we could have gone on for at least another half hour. But thanks again for coming. We really appreciate it. Thank you, Godwin. That's great.